Yes, Mr. Sutcliffe, we received from you, I think, two authorities, Axon and JR38, and some PDF, a couple of PDF emails.
My Lord, I'm grateful, yes, and they have been put into your Lordship's and my Lady's bundle
Right.
by there. So I'll come to those in a moment. I had almost finished the second head of my submissions yesterday on the burden of proof issue.
Yes.
Before I do so, there were 5 points, brief points, arising from yesterday. Does the court have the transcript?
No.
I think it might be.
Have we got it here?
I've got it.
I think it should be on your desk.
Right.
No.
Oh, yes.
I have got it.
Yes.
Oh.
Have you got it, sir?
No.
I think it was given to my lady's clerk. I'm not sure where it will have gone. Can we hand up another?
No, I'm sorry, I don't have it.
Oh, I apologise, my lady. We'll try and.
Should we send a message to your client? She must have put it somewhere. Because we've got it.
Yes.
It was definitely given to my lady's clerk.
Well, don't worry. Why don't you just carry on?
Thank you.
I'll take a note, and then I'll look afterwards.
The first point is page 46 of the transcript.
Looking at the manuscript pages.
That's right. Lines 16 to 19, where my Lord Justice Baker asked my learned friend what was meant in paragraph 190 of the judgment. That's page 182 of the core bundle.
I'm sorry, are you on the little page now?
I'm on the little pages, my Lord.
16.
Page 46.
Sorry.
And it's line 16.
Yeah.
There's your Lordship's question,
Yeah.
and it was this. What does subject to the question of reasonable expectation of confidentiality or privacy?
That's in 190, isn't it?
Mm-hmm.
Exactly, 190 of the judgment.
Yeah.
And that was in respect of the 4849 email.
Yeah.
Yes.
And your Lordship asked what which is in brackets mean there.
Yeah.
We say each time the trial judge used that phrase, subject to, etc., in parentheses in this paragraph, and he does so more than once, he meant subject to the overarching defence. He was simply making the point he had not dealt with the overarching defence by this point in the judgment.
Can I just look at the? Can we just look at 190?
Yes, of
Just
course,
so I
my
can
Lord.
just-
It's page 182 of the core bundle, behind tab 7.
And you're saying he uses this phrase more than once.
He does.
You've control F'd it, have you?
I have. And I submit it was a.
What other paragraphs? You didn't.
Well,
Oh,
even within paragraph 190, he uses it more than once.
Yeah.
Yes, it's at the end of, at the beginning of line 4.
Yes.
Slightly different. Slightly different.
So, yes.
But control F wouldn't work with that.
but that's what we say he plainly intended. But
Subject to the overarching.
defence.
Okay.
But
But that is still different from how it isn't. There is still that distinction with what was said in paragraph 40 of the preliminary issue judgment, isn't there?
My Lord, yes, and I was going to address you briefly on that.
Come back to that when you want.
In a minute. Second, the two authorities I've mentioned, I don't know whether you saw that I gave paragraphs that we're referring to in the email, but just for your note, we flagged paragraphs from the JR38 judgment, which is at tab 12A of the authorities bundle. I'm not proposing to take you there.
Yeah.
Paragraphs we would ask you to look at in Lord Toulson's judgment paragraphs 97 to 99, and then 112. And then in the Axon case, which is at 12b, at paragraph 64, little e.
Yeah.
Third, can I tackle another of my Lord Justice Baker's questions at page 51, lines 16 to 21 of the transcript? If you could kindly turn that up. Lord Justice Baker said this: supposing Mrs. Brake hypothetically had suddenly fallen ill in the middle of an important moment of the business, someone needed to access the account. Supposing that had happened, the password would have been transferred, wouldn't it? My learned friend answers in the following way: your lordship may have heard the answer coming from my client. One can't. It didn't happen. It's dangerous to hypothesize about it. Maybe the answer is no, it wouldn't. This is why the realities matter so much. I'm afraid that answer by my learned friend was not correct. The reality was that other employees had day-to-day conduct of the inquiry's account in any event. So if Mrs. Brake had suddenly fallen ill, Mrs. Holt or Mr. Windus would simply carry on using the inquiry's account in the usual way. In our email this morning, again in the clip...
Mr. Windus is doing that. Mr. Windus is.
My lord, yes. We've included two examples of what actually happened when Mrs. Brake wasn't around to deal with emails coming into the inquiry's account. In both cases, Mr. Windus picked the email up and responded himself using the inquiry's account. And I ask you briefly to read them. And if you take up for that purpose the first supplementary bundle, where hopefully your clerks will have put them into a new 3A.
Yes.
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 Only two emails. But you will see from what should be page 9A, the first of these, an email from at the foot of, in the middle of the page, House Party Solutions, 1st of August 2016, to the inquiry's account, and it's clearly addressed to Mrs. Brake, and it's an inquiry over the New Year period, availability, etc. Response from Mr. Windus from the inquiry's account, same day. Allows out of the office has asked me to reply. And if you go over the page...
How does the response appear to come earlier than the inquiry?
My lord, that was a feature of quite a lot of the emails in the trial bundle. Never ever explained. Is something to do with...
Time zones?
Time... Well, it would be strange. I don't think House Party Solutions are abroad, but it was never quite worked out. But it clearly was a response.
Yeah.
Oh, well, Mr. Day, recollection is better than mine. He tells me it was an error on the disclosure platform.
Oh, right.
So the next page is an email in the middle of the 29th of September of the same year about a wedding cake table addressed to Hi Lovely, and the response comes back from Simon Windus the next day saying, Alo's out of the office, so I have picked this up. And to give you a sense of the scale of the documentary evidence before the judge, I ask you now to put away that supplemental file and to pick up supplemental file 2 and to go to tab 2, page 46, where you should find our opening submissions from trial.
Footnote 40, is it?
Well, yes, it is, my lord, but and it also that in the text, paragraph 24, subparagraph 4,
Yeah.
where we state, Mr. Windus appears to have operated the inquiry's account on a day-to-day basis, and you'll see we gave the series of bundle references. We made the same submission at trial about the documentary evidence of the frequency of Mrs. Holt's use of the inquiry's account, and if you look at the previous page 45, the last line of paragraph 23, where we say that Mrs. Holt appears to have been the primary user of the inquiry's account before she went on maternity leave, and again we give a series of bundle references in the footnote. Now, I cross-examined Mrs. Brake extensively about these emails at trial, and we addressed some of these in our closing submissions, and I ask you to go behind tab 4 at page 115, and when you've got to 115, if you could kindly read paragraph 21, which goes over the page. This takes me on to my fourth point. During the course of her submissions yesterday, my learned friend made a number of factual claims on instructions. Most of them, like this example, were either unsupported by evidence or indeed contrary to the evidence below. It's important to be clear that those instructions were given to my learned friend by Mrs. Brake, whose evidence the judge, and I quote, distrusted except where it was corroborated from an independent source. That's paragraph 28 of the judgment, page 144 of the bundle. So I would ask you to treat with caution any factual claim made on Mrs. Brake's instructions not backed up by appropriate documentary reference. And it simply reinforces the principle articulated in Phage and Sprint Room. You have a fraction of the evidence before you compare to the judge, and you should be careful about disturbing his evaluation of that evidence. Fifth, I wish briefly to come back to the question of the split trial. We say it is not open for the Brakes now to say that the split was inherently unworkable. That is the submission my learned friend made yesterday at page 20, lines 3 to 7 of the transcript. If necessary, we would go so far as to say that is an abuse of process. At the very least, it is a collateral attack on the decision of the 4th of August 2020, which the Brakes did not seek to appeal at the time. Of course, they didn't appeal it at the time, because as I showed you yesterday, and this is transcript page 162, line 14, to 163, line 8, the judge had accepted their application to hive off the factual issues concerned with iniquity. However, we also say that the submission that the split was unworkable is wrong. The split was workable, and it did work. The judge asked whether, with wrongdoing stripped out, there was any reasonable expectation of privacy. If not, it did not matter whether or not there was wrongdoing. That would be the end of the claim.
So on the basis of what the judge decided, there will be no iniquity trial.
Precisely. That's common ground. Wrongdoing would only matter whether at stage 1 or stage 2 of a privacy claim, if the judge reached a provisional view that there was otherwise a reasonable expectation of privacy. It was only in those circumstances that wrongdoing needed to be added back into the mix at a second trial to see if that changed the multifactorial analysis at the first stage, or provided some form of public interest defence at the second stage. Now, finally on this, I can address my Lord Justice Baker's concern about a conflict between paragraph 20 of that iniquity judgment. Sorry, 40 of that iniquity judgment.
Iniquity, you mean
Preliminary.
preliminary judgment? You said
Yes,
iniquity.
I call it the preliminary, the judgment on the preliminary issue, exactly. Paragraph 40 of that judgment and paragraphs 236 and 237 of the main judgment. Can I ask you to turn up Authorities Bundle 2, and if you go right to the back, near the back, tab 21, where you'll find that judgment. And at 644, you should find paragraph 40. We accept that the learned judge could have been clearer in what he says here. However, having reflected on it further overnight, we suggest that the two main judgments of this judgment can be reconciled in the following way. Paragraph 40 of the preliminary judgment is addressing the question of an, and I quote, iniquity defence. The judge uses the word defence, and it comes in a passage beginning at paragraph 27, which is on page 642, dealing with a submission by the Brakes that, and I quote, defences only arise at the second stage of a privacy test, and that the scope for such defences is limited. Now, in contrast, paragraphs 236 and 237 of the main judgment are not dealing with the narrow question of an iniquity defence, but rather whether the relevant wrongdoing could also impact a reasonable expectation of privacy arising in the first place.
Do we know what the preliminary issue was? Is it in an order somewhere?
I believe...
Is that in the main directions order?
I think it is, my lord.
Because one would normally expect a preliminary issue to be formulated as a question for the court to answer.
Yes, and I'm hoping that Mr. Day will find that for me. I'm pretty sure it was formulated. The central question was... paragraph 4 of the judgment.
I see. Whether on the facts pleaded, the iniquity defence is available. So that's the question that the judge was...
Yes, and my lord, it is also in an order. Oh no, it's in an appendix. Oh, it's the list of decreed issues, which you'll find at Supplementary Bundle Volume 1, tab 20.
That was the main order we've already looked at.
That's right, paragraph... Well, it's the list of issues.
Oh, list of issues, sorry.
Appendix 3.
Yeah.
In any event, it's
Yes.
paragraph 20.
Paragraph 20.
Exactly.
Yeah.
So what we submit is that whilst the trial judge is still dealing with iniquity issues at paragraphs 236 and 237, he is not dealing with it as a so-called defence. That's the distinction. I now turn back to the burden of proof issue and deal very briefly with the arguments made by my learned friend in respect of ground 2 of the appeal. There are really only two arguments. Neither of them overcomes the difficulty that the Brakes failed to discharge the burden of proof at trial because they did not show the disputed documents at trial to the judge. The first argument is in my learned friend Skeleton, paragraph 26, page 78 behind tab 2 of the call. Now, this was repeated yesterday, and it is that the judge ought to have simply drawn a binary distinction between business and non-business emails and determined the privacy issue that way. We give 3 reasons why this submission is wrong in paragraph 63 of our skeleton argument, behind tab 3 at page 108, which I'll not repeat now, but ask you to have in mind. I add a 4th reason, which is that it is not consistent with the approach taken by the Court of Appeal in Brown and Associated Newspapers. And if I could ask you to go back to that case, and it's tab 5 of Authorities Bundle 1, at page 100, tab 5, page 100, and if I could just ask you to read paragraph 36 of the Master Rolls judgment.
Yeah.
And for your note, the same point is made in paragraph 50 at page 104. Second, and in the alternative, my learned friend argues that the judge ought to have directed himself by reference to the 16 categories of email set out at paragraph 27 of her skeleton argument. That's tab 2, pages 78 and 79. She repeated that submission on her feet, and my Lord Justice Lewison raised it with me in my submissions yesterday afternoon. It is correct that the 16 categories were included as an agreed issue and not addressed in the trial judgment. The court, of course, is not bound to adopt all aspects of a list of issues, and we say that failing to adopt part of the list of issues in the judgment does not amount by itself to an error in the sprint room sense. Trial judges depart from lists of issues all the time. It's certainly not a sprint room error in this case, we say, for 2 reasons. First, I go back to the fact that this is about the burden of proof. The court could not address these 16 categories because it was not in a position to make any findings on these categories. And that is because the break showed the court no disputed documents at all in 9 out of the 16, and very few disputed documents in the remaining 7. If you would kindly turn to tab 4 of the call and to page 117. This is the appendix to our skeleton argument. You need to look at it in landscape form. We have given you the references to the few documents that were shown to the court during trial. There was no argument by the breaks at trial that these few documents shown to the court were a sufficient basis to make general findings in respect of those categories. It's very difficult to see how that argument could have been sustained even if it had been made. Take, for instance, the example of the medical emails to which my learned friend repeatedly referred in her submissions yesterday. None were shown to the judge at trial.
Well, I think you said yesterday they were among the
Exactly.
materials that were destroyed.
That were destroyed. Mr. Spendlove's unchallenged evidence was that they had all been identified for destruction, as my lord says. No medical emails were in dispute at trial. But in any event, without seeing the alleged medical emails, the court had no way of knowing whether these were trivial or mundane. There's an obvious difference between an email confirming an appointment or a change in contact details at the GP surgery and something which actually contains information about a person's medical history. And the court was not provided with any evidence the medical emails had been looked at by the Guy parties other than to identify them for destruction. The court was also not provided with evidence at trial to suggest the medical emails were disseminated in any way to third parties, or that the Guy parties were threatening to disseminate those emails. So it simply wasn't in a position to make findings that any particular category of documents attracted a reasonable expectation of privacy, or that there was any misuse in respect. Put another way, the judge had no evidential basis to say that any tort had been committed in respect of these categories. So far from it being a sprint room error not to engage with these categories, we say in the absence of evidence, it would have been an error in the sprint room sense to have done so. The second and related point is that the breaks never bothered to set out how these 16 categories mapped onto the documents over which they sought an injunction. We expected them to do this at trial, but they didn't do so. And it wasn't for us to do this. It was the breaks claim, and they bore the burden of proof. Because they didn't do this mapping exercise, the court could not use this categorization to make an order for an injunction over particular documents. It would have been an entirely academic and abstract exercise to try to make findings as to these categories. It would not have led anywhere in terms of relief. So we say there was good reason for the judge to refrain from engaging with these categories. Certainly doesn't amount to an error in the sprint room sense. And it follows from the outcome of the trial judgment that it would have been no different had the judge directly addressed each of the 16 categories. We say he would have been driven to make the same points that I have just made. My learned friend obviously recognises she has difficulties on the burden of proof, which is why she suggested in discussion with my Lord Justice Lewison yesterday, and this is page 115 of the transcript, lines 23 and following, that there was some sort of reverse burden of proof which arises where the content of documents is alleged to be obviously personal. We say there is no authority to support that proposition. Indeed, it is contrary to the multifactorial approach set out by all the leading authorities which the judge followed in this case, in which there is no single factor which presumptively leads to one outcome or the other. So unless the court has any questions on ground 2, I now propose to move to the overarching defence and the remaining 2 grounds of appeal.
Yeah.
I begin by going back to where ground 2 ends in the trial judgment, and that's at page 182 behind tab 7 of the core ground. Page 182, and we finished on paragraph 190, about which my Lord Justice Baker asked that question. We do not understand anything to be challenged in the judge's reasoning until paragraph 230, which is at page 197, where the judge deals with the overarching defence on confidentiality at paragraphs 230 to 233. Now, confidentiality is ground 3 of the appeal. I deal with this very briefly, given that my learned friend barely touched on it right at the end of her oral submissions yesterday. In both her written and oral submissions, my learned friend effectively repeats her arguments on ground 1 in ground 3. She did not explain how, on her case, ground 3 could succeed if ground 1 was dismissed. It follows, I respectfully suggest, that if you dismiss ground 1, ground 3 should also be dismissed. And we simply say on this head that the judge applied the orthodox 3-limb test from Coco and Clark. Mr. Justice McGarry, there is no error in his evaluation of the evidence that would entitle this court to reach a different conclusion. So if I can now turn to ground 1 of the appeal, privacy. This ground challenges the reasoning in paragraphs 238 to 268 of the judgment. That starts at page 199 of the core and goes through to page 208. I'm not going to take you paragraph by paragraph through this part of the judgment, but I would ask you to note that the critical reasoning of the judge lies in only 6 paragraphs. That's paragraphs 239 to 245 on pages 200 to 202. And of these 3 paragraphs, that's 239, 244 and 245, address arguments which are no longer pursued on appeal. So the focus on ground 1 has to be on the remaining 3 paragraphs, 240, 241 and 242, whether, having regard to the preceding paragraphs of the judgment, which are largely left unchallenged, there was an error here in the sprint-room sense that would entitle you to conclude that the judge went beyond the ambit of conclusions a judge could reasonably reach. My submission, there's nothing in the arguments of my learned friend that would lead to that conclusion. Indeed, one oddity of the argument yesterday was that she simply didn't analyse the reasoning in these paragraphs. And in our submission, it's very difficult to see how ground 1 can succeed without engaging directly with what is said in these 3 paragraphs. You can't get over the sprint room hurdle by simply ignoring what the judge said below. We say that many of the contentions by the breaks on ground 1 of the appeal are simply incorrect on any proper reading of the trial judgment. For the reasons I gave under the first head of my submissions yesterday, the error section, I briefly remind...
I mean, his main reason seems to be, in paragraphs 241 and 242, that Mrs. Brake was using what you called yesterday shared space.
Yes. Absolutely. Can I just briefly remind the court of 6 key points I made yesterday, and they are set out in our skeleton.
Yeah.
At paragraphs 36 to 45, that's behind tab 3 of the core, pages 98 to 100. First, contrary to the starting point in my learned friend submissions, the Guy parties never accepted that the 5,500 emails were private to Mrs. Brake. The overarching defence had always been that nothing in the inquiry's account was private to Mrs. Brake.
Now, the judge, where does the judge use that phrasing?
He uses the phrase, I think twice my learned friend took you to it, but then I took you, when I started yesterday afternoon, to where the learned judge had made it very clear he accepted. We never accepted it was private. I think it was in particularly dealing with the permission to appeal, and it was in his judgment there.
Yes.
There was no admission or finding at the trial to the contrary. But second, the inquiry's account was only set up by AEL, the company, in 2015, always paid for and belonged to AEL. This was not, as was alleged and rejected at trial, an email account that belonged to the Brakes. The judge rightly gave weight to AEL's ownership of the inquiry's account, but nor did he treat it as decisive, as opposed to something that weighed in the balance. Third, the Brakes claim faces the multi-user obstacle, as I just agreed with my Lord Justice Lewison. We say that it was the most important factor for the reasons I gave in opening. Employees other than Mrs. Brake had access to the inquiry's account, and that access was unrestricted, not limited, as was wrongly suggested by my learned friend. She was driven to accept yesterday that this was a fact, and that, if you'll note, is transcript page 57, lines 15 to 17. Fourth, there is the fact that at the time the General Inquiries account was set up by Mrs. Bray, she was also provided with a dedicated Allo at Axnola email account. My learned friend was also driven to concede yesterday that this was a relevant fact, and that's transcript page 105, lines 15 to 24. Fifth,
Sorry, the page number again?
105, lines 15 to 24.
Thank you.
Fifth, AEL itself always had unrestricted access to and control over the inquiry's account through its employees and its retainer with the IT administrator ACS. My learned friend is wrong to contend otherwise for the reasons I gave yesterday. And sixth and finally, Mrs. Bake's employment contract ran contrary to rights of confidence and privacy, as did the warranties in the SPA which she negotiated. Now, if the court accepts those submissions, there is nothing left of ground one. Because if once you've accepted those 6 key points, it follows that all the factors point away from a claim in privacy in this case, other than the alleged content of the disputed email. The alleged content of the emails really is my learned friend's only argument. And as I've already sought to show, the content point goes nowhere because the judge was not put in a position where he could make any findings about the alleged content of the disputed email. And in this regard, can I refer you to a critical exchange between my Lady Justice Asplin and my learned friend yesterday? And for this purpose, could I actually ask you to go to the transcript, page 44. I fear I don't think my lady...
I have now.
Oh, you have. Page 44. I'm grateful. And this is what if you have page 44, this is what my lady described as her potentially stupid question. But I respectfully say, in fact, cut right to the heart of the case. My lady asked, do you see in line 2, on that basis, the judge had to take all relevant factors into account when determining that first question, and therefore just determining or saying that it had been agreed that certain emails were private is not necessarily enough on its own. And you will note that my learned friend did not answer that question, but tried to reformulate the question into something else. And the reason why my learned friend could not answer that question is because there's really nothing to ground one other than the alleged content of the disputed emails. All the other factors identified in the trial judgment pointed away from a reasonable expectation of privacy. My learned friend is effectively asking you to conclude that the content of the disputed emails is the decisive factor in this case, and that the judge was clearly wrong to prefer all the countervailing factors. This is my learned friend's central submission. Indeed, on analysis, it was really her only submission on ground 1, which was repeated in a number of different ways. And we say it must be rejected for 3 reasons.
Well, you showed us, I think, the passage in Immerman where, while postulating the husband who leaves his bank account, his bank statement, open in a shared space with his wife.
Yes.
Might have been private had he kept it to himself.
Yes. Yes. My lord, yes. We say this submission cannot be right for 3 reasons. First, the law is clear that the content of the documents is not decisive of a reasonable expectation of privacy. This is necessarily a multifactorial exercise, and then I quote, and all the circumstances must be taken into account. One does not need to look beyond the case of Murray, paragraph 36, to which my Lord Justice Lewison referred yesterday. That's at Authorities 1, tab 6, page 136. So the trial judge correctly applied the law when he did not give decisive weight to the alleged content of the disputed email. Second, we say there is no gap in the logic of the trial judgment, no lack of consistency, no failure to take into account some material factor, no other flaw in the sprint-room sense in choosing to give weight to all the countervailing factors. I have identified especially the multiple users point, which I say makes this case stand out as being especially weak, and to which my learned friend has no answer. The trial judge was well within the ambit of conclusions a judge could reasonably reach by preferring those countervailing factors over the alleged content of the disputed email. And then, thirdly, we say the trial judge was right, obviously right, not to give decisive weight to the content of the disputed emails, because of course he hadn't been provided with the necessary evidence to make any positive findings about the content of these emails for the reasons I've given. So, given the failure to adduce the correct evidence at trial, it would have been perverse to reach any other conclusion. So those 3 points we submit provide a complete answer to ground 1. But even if you are not with me on that, I fall back to the point I made in opening, that Article 8 protects respect for private correspondence, not private correspondence per se. The judge found, and this is paragraph 125 on page 166, that my clients bent over backwards to help to allow Mrs. Brake to remove personal emails from the inquiry's account immediately after she was dismissed, and she refused those offers. In those circumstances, we say respect for any private correspondence was shown, and Mrs. Brake was in effect put on notice that if she did not take her personal correspondence off the inquiry's account at that stage, it would be accessible to the Guy parties. As my Lord Justice Lewison put it at page 138, lines 3 to 6 of yesterday's transcript, Mrs. Brake had no reasonable expectation of, and I quote, continuing privacy after having refused the opportunity to take personal material off the business account. This is not a point that is unique to work email accounts. One can think of any number of other examples. First, one might take my Lord Justice Lewison's notepad example. That's at page 152, lines 14 to 17 of the transcript. If you wrote down something personal on a notepad at work, and would then...
Notebook, I think, my Lord's.
Notebook, yes.
Positing,
Thank you.
writing a note in my
Thank you, my Lord.
advice.
Notebook. And you were given an opportunity to remove it when asked to do so by your employer, and did not do so. You cannot reasonably expect it to remain private thereafter. Second, you might make the analogy by reference to leaving personal documents in a filing cabinet at work. If you were asked to sort out that filing cabinet on your departure, and you unreasonably refuse to do so, you cannot reasonably expect your to assert privacy over something personal left at the bottom or in the middle of it. Finally, you could make the analogy using the shopkeeper example that we used in closing submissions at trial, to which I took you yesterday, and for your note, that is in Supplementary Bundle 2, Tab 4, page 158, paragraph 111, subparagraph 4. So for these reasons, even if you were to accept my learned friend's submission that the alleged content of the disputed emails should be given decisive effect on whether Mrs. Brake had a reasonable expectation of privacy during her employment, we say it's no answer to what happened once Mrs. Brake was dismissed. And before finishing this third head of submission, I should briefly address the authorities cited by my learned friend on ground 1 of the appeal. As a starting point, I refer you back to the judgment in Brown one last time, and that's Authorities 1, Tab 5. And if you could go to page 99. And if I, page 90, tab 5, page 99.
Paragraph?
Paragraph 33, if I could just
Yes.
ask you to read paragraph 33. Now, as paragraph 33 makes clear, the question of reasonable expectation of privacy is fact-sensitive. Each case turns on the evidence before the court. There are no bright-line rules. Follows from this that previous cases are primarily relevant insofar as an analogy can be drawn between the facts of that case and the facts of this case. In her skeleton argument, my learned friend relied on 3 decisions of the European Court of Human Rights, Halford, Copeland and Barbulescu. Taking these in turn, At trial, the Brakes relied on Copeland and Barbalescu, and we deal with them in our closing submissions at trial. And if I could ask you just to turn to Supplemental Bundle 2, so put away Supplemental 1, and in
Tab 4.
tab 4, exactly, page 146. And if I could ask you to read subparagraphs 1 and 2 of paragraph 91. Now, Barbalescu appears to have been dropped. It hasn't been included in the authorities bundle for this hearing. Although Copeland was kept in the authorities bundle, and indeed my learned friend, I think, referred you to it, with respect, she hasn't explained how it could assist for the purpose of drawing an analogy, given how few facts are recorded in the report. We say that Copeland cannot be understood as imposing a bright line test, turning on warnings in employee work email cases. Each case requires a multifactorial assessment of all the circumstances. But even if that is the effect of Copeland, we say Mrs. Brake had the necessary notice when she was given the opportunity to take personal material off the business account after her dismissal, but unreasonably refused to do so. As for Halford, this was a case which the learned judge identified for himself because it was cited in Copeland. And for your note, it is dealt with in the judgment at paragraphs 249 and 250, which is pages 202 and 203 of the court.
What appears to have happened in Alford, as far as one can tell, is that Assistant Chief Constable Halford had two phones, one of which was personal and one of which was, so to speak, the office police phone. And as far as one can tell, calls from both were intercepted or monitored.
My Lord,
Because of the use of the plural telephones.
exactly. I think we have to concede that, but the limited report of the facts, in my submission, only reinforces how careful you have to be to draw an analogy. One can quite see. Maybe the court did find the tapping of both lines objectionable. Certainly, tapping a personal telephone line would be objectionable. One doesn't know what the precise facts were in relation to the work. But the key feature we submit of Halford was that she was given a telephone line by her employer, which she was told was not was dedicated for her own use and for her private use. We submit that could not be further from this case, where the inquiry's account was not for the dedicated use of one person, still less was its purpose for private communications. And Mrs. Brake never received any assurances from AEL like Mrs. Halford received from her employer. In fact, AEL gave Mrs. Brake a separate dedicated email account, allo at Axola. So if the analysis in Halford could be read across, it would apply to that dedicated email account, not to the general inquiries. Now, the other decision which my learned friend relies upon,
I'm sorry, could I just interrupt? In relation to Halford also, there is the factor that Miss Halford had been given the assurance that she could use the telephones for the purposes of her discrimination case. So that had been given by her employer in relation to a specific class of communications.
my lady, yes, that is a very important point and a critical distinction, we say, in the facts of this case. The other decision, which my learned friend relies on, and I think this is core tab 2, page 77, paragraph 25, is the decision of Mr Jarvis, QC, when ordering the interim injunction in this case.
Sorry, core tab 2, page
Page 25.
95.
Sorry, paragraph 25, page 77.
Yeah.
There's reference to what's called the Jarvis judgment. Now, with respect, this is a thoroughly bad judgment, which we asked my learned friends to withdraw in advance of the hearing, but it appears they haven't done so, which means I must deal with it briefly. The deputy judge, who is incidentally is Mr John Jarvis, QC, in my chambers,
Yeah.
who is not a circuit judge, although he's referred to that in
Well, that doesn't matter, does it?
numerous places.
He
No.
was presumably sitting as a High Court judge in
He
Bristol.
was, exactly.
Yeah.
He was applying the threshold required by American Sign Language.
Yeah, well, he had to decide whether there was a serious issue to be tried.
Exactly. And he made it clear that he was not making any findings. And the relevant passages are quoted in the trial judgment behind tab 7, page 141, at paragraph 19, page 141. It should also be noted that the case put to the deputy judge was that the inquiry's account was owned by Mrs.
Yeah.
Brake and covered by confidentiality. As I explained at the outset of my submissions, the trial judge found against the Brakes on both these points. And at trial, my learned friend doesn't seek to challenge them on appeal. So the case put to this court has changed really out of all recognition to the case put to Mr Jarvis 2 years ago. And there's nothing useful to be gained from going back to his judgment. The only other authority about privacy in a work mail account is the case of Simkin, which, if I could ask you to take up bundle 2 of the authorities, and you'll find it at tab 13. An learned friend doesn't ask you to find that Simkin was wrongly decided. He simply says the analogy drawn from it was incorrect. And we ask you to reject that submission. We say there are striking parallels between this case and Simkin, which reinforce the conclusion that the judge reached in this case. And the key passage...
Well, that may be, but you just told us that you can't really draw analogies from other cases.
Well, what I said, you can only draw analogies, so...
I don't think you were quite as
Dogmatic as that.
Dogmatic as that. You said extreme caution.
You have to be careful, and I was. The trouble with Copeland is you don't really know what the precise facts were. But
there are some similarities and some differences.
Precisely. But can I just ask you to look at what we say is the key passage on page 459.
Yeah.
Paragraph 34, where you will see that Mr. Justice Garnham says it was impossible, and I emphasise the word impossible, for the claimant to maintain a claim of reasonable privacy for 4 reasons. First, this document was on the company's servers. That is also true of this case. Second, the document in Simpkin itself was not password protected. That is also true of this case. No individual documents were password protected, and the password for the account was not exclusive to Mrs. Brake. It was one to which AEL and its employees were entitled to have or change, for the reasons I gave earlier.
And when Mr. Justice Garnham says it wasn't segregated, what he means it wasn't in a separate folder on the email account,
I'm not quite sure. Maybe yes, I think so.
Is that the third point?
It is. The third point is that the document in Simpkin was not segregated from work documents, but mixed in with them. And we say that's true in this case. The minority of personal emails were mixed in with the bulk of the account.
Was there any finding about this?
By the judge?
Yeah, about on the segregation point.
I'm sure we can find, yes, but I mean, there's certainly no question at all that's the case. Of these 60-odd thousand emails, there was no, they were all in the account unsegregated. Now, the bulk of the account was business related. Had Mrs. Brake wished to segregate her personal emails, she could easily have done so by using the separate dedicated account given to her or one of her personal accounts. And then fourth, and critically, was the multi-user question, which Mr. Justice Garnham addresses at paragraph 35. In both cases, the claimant was aware that other employees could access the account. And as Mr. Justice Garnham puts it in the second sentence, the mere fact of access by another employee, even if that employee did not actually read any, undermines, that's his word, the suggestion that the claimant had a reasonable expectation of privacy as against them.
Well, there is a difference, isn't there? As I read it, it may not be, it may not have any consequence, but the difference is that the emails, it wasn't the question of the PA having access to the same account. It was the emails showed up in the PA's own email account.
Your Lordship is right.
Whereas in this case, several people had access to the same account.
That's right, my Lord. I respect this bit. That isn't a material.
Well, insofar as I suppose you might say, it helps you.
I do. I say this case is actually stronger
Because that's a specific. For example, it's open, and some judges have their clerks have access to their emails. So there's a specific arrangement.
Yes.
In the way it's set up.
Yes.
That's not the case here.
No.
It was one account on your to which several people had access. So it's a stronger point.
That's right. Now, if one then turns to the conclusion the judge reached in this case, can I ask you to go to the core, tab 7, and it's page 208. And his Lordship's conclusion is at paragraphs 265 266 on page 208, which I ask you to read.
And there's the conclusion that they were not segregated in 265.
Thank you, my lady. Thank you.
Yeah.
Now, in our submission, that reasoning cannot be faulted. There's certainly no basis for identifying any error in the sprint set in respect to the comparison which the judge drew between this case and Simpkin.
Well, what I think Ms. Rogers says is that by focusing on paragraph 34, the judge failed to take into account the other factors in the surrounding paragraphs in the evaluation. That's what she said, wasn't it?
Well, that is, you're quite right, my lord. That's what she said. We say that you must reject that submission. That it's effectively only the cumulative effect of the 6 factors in Simpkin which led Mr. Justice Garnham to the conclusion that he reached.
Sorry, are you saying that's what Mr. Justice Garnham said? Or
No, it's what it's what my learned friend submitted. If you look at the transcript, page 78, lines 11 to 13, I understood my learned friend's submission to be that it was only the cumulative effect of the 6 factors in Simpkin which led the learned judge in that case to the conclusion that he reached. And we submit that puts an interpretation on the judgment which it cannot fairly bear. But in any event, we ask you to look back at Judge Matthews' judgment at the top of page 208, paragraph 264, where it is clear, we submit, that the judge did take account of the differences, as he saw it, between Simpkin and this case. He gave 3 differences there. So,
But his reasoning, the reasoning which leads him to his ultimate conclusion in 267, which he expresses as overall taking into account all the circumstances of the case, is not, as I read it, limited to what he says in 265 and 266. It includes, for instance, what he said at 261, that Mrs. Brake had her own email account, which she could have used if she wanted to, and various other strands in his reasoning further back in the judgment.
my lord, that is right. And he also simply says that, and he also takes account, you're right, of 261, he also takes account of paragraph 24, what he said in 242.
Yes.
But my lord, and all he's saying here in 266 is that the position in the present case is analogous. So he's simply getting some help.
I think Ms. Rogers' point is that the way he expressed it attached a greater weight to the 34 facts in paragraph 34, Mr. Justice Garnham's judgment.
Well, my lord,
But your point
I
is that
respectfully submit that's wrong. It is in fact paragraph 34 and 35.
Yeah.
And I respectfully submit that puts an interpretation on the judgment it cannot fairly bear. I've nearly finished. Can I just make 4 sweep-up points? Firstly, on the judge's findings, there was no misuse of confidential information. That is the first half of ground 4 of this appeal. And we have little to add to the judge's own reasoning, which we say was compelling. And you will find our written submissions on this at paragraphs 67 to 69. of our skeleton. That's at tab 3, pages 109 and 1110. And in any event, we say you never get there because to reach ground 4, my learned friend needs to first to succeed on both the overarching defence and the burden of proof issue. Second, for similar reasons, I'm not proposing to address you on the second half of ground 4, namely the quantum of damages. The parties agree that the applicable principle are those adopted by Mr Justice Mann, approved by the Court of Appeal in Gulati. That's Authorities Bundle, tab 2, second Authorities Bundle, tab 11. The judge's award was within the Gulati range, albeit towards the bottom. We submit that outcome was undoubtedly right, given the findings of primary fact that he'd made, none of which is now challenged. Third, my learned friend relied heavily on Imamman and Cengiz. There is no principle of law from that case which the judge did not follow. And there is also no analogy to be drawn between Imamman and this case. This was not a case of self-help. My clients looked at documents in their own email account. They did not help themselves to the Breaks email account. And can I ask you just to turn up Imamman briefly? It's in Authorities Bundle 1, tab 9. And I could ask you to go, when you're there, to page 260. And it is paragraph 12 of Lord Newberger's judgment. I could just ask you to look at that.
Yeah.
You'll see that the facts were that the brothers-in-law shared an office. When it looked like Mr. Imamman was going to get divorced from Mr. Cengiz's sister, he accessed Mr. Imamman's account without his permission and took a significant number of documents from it. And the key part of the reasoning is at paragraph 68 on page 276, which I ask you to read. The Breaks relied heavily on this authority when seeking the interim injunction and at trial as part of their case that the inquiry's account belonged to them. The judge rejected that case. He instead found the inquiry's account belonged to the Guy parties. This was not a case of the Guy parties helping themselves without authorization to the Breaks email account, but rather a case of the Breaks putting correspondence onto the Guy parties email account without authorization. Now, just nearly finally, whilst on the question of self-help, having thought more about the question put to me by my Lord Justice Lewison, transcript, page 161, line 8. We don't need to go there, but my Lord will recall, regarding an employer's right to investigate, to identify whether there has been wrongdoing. I believe the correct answer is this. If an employee has a reasonable expectation of privacy in respect of an email account, the employer is not permitted to look into the contents of that account, even if he suspects wrongdoing, as that would amount to self-help and be contrary to IMO. If, however, the employee has no reasonable expectation of privacy, the employer is free to do so. And then the final of my 4 points, sweep-up points, it is just very simply this, that the second appellant, Mr. Brake, never had access to or used the inquiry's account. He had no documents, confidential or private to him, on the account, and this appeal is all really about Mrs. Brake. And then if friend hasn't explained Mr. Brake's position on this appeal either in her skeleton or submission, we don't understand why he was a party at first instance and are at a loss to know why he's a party to the appeal, but on any view his appeal ought to be dismissed. Unless I can assist you any further, those are my submissions.
Thank you.
I've got 2 questions, if I may, Mr. Sutcliffe. First arises out of JR 38. I could just turn that up. We've got it now in tab
12A.
12A,
Or bundle
volume 2. Now I'm looking at Lord Toulson's judgment, which seems to command the majority.
It does.
In
Paragraph
particular, paragraph 98.
Yes.
So one of the factors which he considers bears on the question of reasonable expectation of privacy is the use to which the published material is to be put. And he says, for instance, publishing a photograph of a young person acting in a criminal manner for purposes of identification may not fall within the scope of protection, but publication of the same photograph for another purpose might. And that, I think, mirrors a point that I was putting yesterday, that something may be private for some purposes, but not for others. So I wondered whether you wanted to say anything about that point.
My lord, yes. We would respectfully obviously agree with and endorse that point. And I'd simply refer you to the consideration that the trial judge gave of the use to which these documents were put by the guy. He dealt with it in detail, and we respectfully ask you to effectively approve of the way he dealt with it.
Which paragraph numbers, Mr. Sutcliffe? Can you give me that before?
Yes.
Mr. David do that. Yes, please.
My lord, yes, it's pages 67, paragraph 6. Maybe I gave you the wrong reference earlier. I had 67 to 69. Page 210. Yes, it's the section of his judgment starting with the heading application to facts.
Yes.
Paragraphs 274 onwards, and it really goes on to his conclusion in 293 about what the damages would have been. Occurring a breach of contract. And also at page 169, which I think was what I might have referred you to earlier.
So, page 169 or
Page
paragraph?
169, paragraph 140 through to 157 on page 173. That's where he sets out what happened.
Yeah. Right, my second question, what, if anything, should we make of the judge's finding in paragraph 160? At the end of the paragraph.
Simply to uphold it. There's no grounds for overturning that finding. In the Sprint-Room sense, it can't be shown that he's taken account of any factors.
Well, I was thinking of what this court said in Murray, when substantial offence seems to be one of the key ingredients of engagement of the right of privacy, or right of a reasonable expectation of privacy. We get that, I think, from Murray at first paragraph 35.
Yes.
So the court's looking at whether there's a reasonable expectation of privacy, it's objective, reasonable expectation of the person who's affected by the publicity, and then this court applies what Lord Hope said in Campbell. The question is what a reasonable person of ordinary sensibilities would feel if she were placed in the same position as a claimant faced with the same publicity. And here the judge appears to find that no reasonable person of ordinary sensibilities would be substantially offended. And I think we know from elsewhere that there has to be a certain seriousness before there is an invasion of Article 8.
My Lord, yes. So what we submit in relation to that finding is that it doesn't just go to breach. It also undermines the case at stage 1 of this claim. And it is one of the matters that needs to be taken into account.
I mean, you might, I suppose, say that even if it goes to breach rather than reasonable expectation of privacy, what it doesn't do is touch the question of iniquity, and therefore what has happened on the judge's findings is not an interference with the right under Article 8 or privacy.
That's right. That's right.
Yeah. Well, what do you say to Miss Rogers' submission that it was a perverse finding?
With respect to her, she hasn't actually identified, at least I couldn't follow from her submissions, the grounds on which that could be said to be perverse.
All right, thank you very much. Yes, Miss Rogers, do you wish to reply?
I'm afraid so. I'll try to do so, obviously, as quickly as I can. And so I'll move this back here in case it matters for microphone purposes. I was going to start with what are said to be the 7 errors which were raised yesterday, 6 of which were mentioned today in a slightly different guise, but they're the same points. I'm afraid I can't do this by reference to the transcript. One appeared in my inbox last night. I wasn't expecting one, and I haven't cross-referenced to it, but I hope it'll be sufficiently clear. And if the transcript references are wanted, perhaps somebody behind me will be able to come up with it. The first one, and of course it matters because this isn't. I accept that these points are points on which we disagree, on which there are arguments either way, and that's not a question. But it's not put that way. They were put as being errors of fact, which have effectively been misrepresented. And of course, coming new to the case, one's always alive to the risk of that kind of thing. One wants to be very careful, and we've obviously tried not to misstate anything in the first place. And I've gone back over it, and I'm going to deal with them. Both as whether or not they're errors of fact or actually whether a little bit about the arguments without, I hope, repeating myself. I'd rather stopped if I tried to. The first is that the guide parties accepted that 5,511 emails were private. I'm afraid we don't accept this as an error. And we say that, first of all, and these are points which I've taken the court to yesterday, were the passages in the judgment. J1, sorry, I use J reference to the paragraph.
Yes, that's
numbers,
fine.
if I may do that. J169, which is page 176, the defendants finally accepted that 5511 were indeed private. J171, page 177, I'm not going to take the court to this unless you want to, of course. The defendants accept that 5,511 are private and should be deleted. J174, page 178, he's dealing with the cross-examination of Dr. Guy. Dr. Guy accepted in a general sense, without reference to any documents, it's fair to say, that if the emails were not AEL business emails, they were private emails. The judge says that's not conclusive. I accept that is not conclusive on the question of whether there's a reasonable expectation of privacy, but in terms of whether or not the emails are private, Dr. Guy accepted that they were. That's what the judge said he accepted, and it is indeed what he did accept. That paragraph, J179, also records the judge the judge recording that Dr. Guy had accepted that emails between the Brakes, plural, I'll come back to Mr. Brake right at the end, between the Brakes and their lawyers were private. Now, that paragraph, this is a small error by the judge. He deals with that in the context of the 3,149 emails. Actually, he should have been dealing with it in the context of the 4,849. It matters not. It comes from Mr. Spendler. Dr. Guy deals with it, and Dr. Guy accepts that that's the position. They are private. And the reference back to the source about this, for example, is Spendler 3, of course. Then this includes, he's being asked about Mitchell-Moore's, and Mr. Spendler says in his statement, in just categorising the documents, Mitchell's may also have been instructed for the claimants in their personal capacities and as trustees. And that's supplemental file 2, the second supplemental file, tab 21, page 233. And in fact, probably this is a convenient moment just to deal with a stray point about Mr. Brake, if I could put it that way. It was submitted at the end of the trial that Mr. Brake had no rights. If I say so, it was a bad point then, and it's a bad point now. The explanation why that's the case is in the second. There are two sets of closing submissions on both sides. On the claimant's closing submissions, the second set, at paragraph 10, the reference is at is second supplemental file, tab 5, page 172. It's paragraph 10. And
Page
172.
172.
Tab
Do you want us
5.
to look at it?
No, I don't think it's necessary. It's simply it's recording the point that the emails there are emails in relation to Mr. and Mrs. Brake, in relation to solicitors, in relation to trustee and bankruptcy matters, in relation to the old partnership matters, because
So
Mr. and
he
Mrs.
may have some
Yes.
rights, but less extensive than Mrs. Brake's. Is that
He
the
wasn't
position?
using the account, and she was, so it's less extensive. But some of the materials are common to both.
What expectation of privacy does he have in relation to personal matters about him, which arose on an account to which he had no access?
Well, it's his wife. Well, the husband and wife are not the same person, obviously, but it's his wife who's using it. So it's not as though it's some stranger who is using an email account. It's his wife who's using it. So his rights are protected as hers are. They're joint rights. And the point made in the closing submissions is if Mr. Brake hadn't been there, it might have been said, well, Mrs. Brake can only protect her own interests, not Mr. Brake's. It's a very small point.
Yeah.
I've given the reference to the claimant's closing submissions. I should mention that, of course, there is a response to that from in the second set of defendant submissions. That's in the next tab, tab 6 of the second supplemental file, page 178 at 5, and again, it's just for completeness. It isn't that he owned the account. We're not arguing that there's an ownership of the account point, but the argument is about emails on the account which contain private information relating to those individuals. As I say, the Spendler 3 categories refer in a number of places to the claimants plural, legal advice, trustee in bankruptcy, and so on. So that's how that arises. So had the claimants accepted they were private, I am not suggesting that the defendants had accepted that the claimants had a reasonable expectation of privacy. That's not what I'm saying. But in relation to what they're saying about private material on the account, again, I know the court doesn't want to go to the transcript. Mr. Bowyer, on day 3, transcript page 86, lines 2 to 10, and this is the second supplemental file, tab 9, page 300, asked if he knew that Mrs. Brake used the account for private emails as well in business. Well, I don't know when I was made aware of that, but I'm sure she probably did. Most people do.
I think Dr. Guy accepted that, as the judge records in his judgment.
Well, so does Mr. Bowyer. It's the defendants. There's a general acceptance about private emails, and there are, as I say, there are references in Mr. Guy's evidence for that.
Yeah, people use their employers' email accounts for personal emails.
Yes, there are, but they do use
that.
it, and they did use it.
Yeah.
People generally do, and these
Yes.
well, this individual did.
But as you quite rightly say, that doesn't translate, or at least not necessarily translate, into a reasonable expectation of privacy.
I'm accepting
in
that.
the sense in which that's used in
Of
the law.
course, of course. I think, but I don't know whether it's used outside the law, but the question of whether they're private is something that's there. I won't trouble. There are plenty of references in the transcript, and specific documents are put to Dr. Guy from the Spendler account, and as I say, he accepts that the correspondence between the Brakes and the trustee in bankruptcy are private. Yes, that's quite reasonable, he says. Miscellaneous, you accept that it's none of your business to go through the personal emails. Yes, he agrees. So that's where it is. So we don't. I'm afraid we don't accept that that we're in error when we say what we do. I would be in error if I said they'd accepted there was a reasonable expectation of privacy. I don't say that. Didn't say that. Don't say that. And it's not in error. And in terms of what everybody thought at the time, one's got to focus at how things were at the time. By the time we end up at trial, the word personal is being used much more than the word private, but particularly by the lawyers. But when Dr. Guy was asked about this particular email that's sent to Mr. Windus on the 9th of November after the sacking, and as the transcript records, Dr. Guy writes to Mr. Windus that the inquirer's account should be accessible by yourself, that's Windus, and as soon as you've taken off Allo's private emails, and then added KMG, I'm afraid I don't know who KMG is, and Natasha, that's what he's using. Take off the private emails. That's what we're really talking about. And so when one ring fences the 5,511 emails, the word personal is being used because what Mr. Spendler is doing is still the review mechanism from His Honour, Mr. John Jarvis QC sitting as a High Court judge, or he's the deputy. The division is business, AEL business, effectively that's yours, personal. That's the binary split, and that's what Mr. Spendler is dealing with. Now, we say the judgment is clear. We say the judgment is right based on the underlying evidence and the references there. Mr. Sutcliffe goes to the permission to appeal judgment to suggest that this in some way calls into question what it is. But that we have to wrap up. We don't think it's appropriate or helpful to try to put that gloss from the PT.
Does it matter all this? Does it matter whether they're labelled private or personal?
Well,
Given that it doesn't, given that this doesn't import an acknowledgement of a reasonable expectation of privacy, why does it matter what you call them?
Well, it matters because it's how you see them and how you're categorising what's on the email, what's on the email account. If it's personal to someone, what's the difference as your starting point? If it's personal.
Or can you think of something that's personal and not private? Leaving aside the expectation point. I can't.
Well, I think there are all sorts of personal things which if
Don't
one's
think the
disclosed.
appeals- I don't think the appeal is going to turn on this point.
Well,
not.
then fine. I'm not. I take the view that if one's wrong, one corrects, and we don't accept we're correct. If there are things that are personal that could become publicly known, and they would cease then to be private. But if they're simply personal, then that we say is where the scope of private information lies. That's where the tort lies, and it's that breadth of. I think it's from Immerman. I think it's paragraph 67 of Immerman, where he's putting 76, not 67, but put in very broad terms by the court, communications which are concerned with an individual's private life, including his, I interpose her or their, personal finances, personal business dealings, possibly his, her or their, other business dealings, are the stuff of personal confidentiality and specifically covered by Article 8. So that's, we're in the word bucket is used in the
I mean, that quote, which I didn't write, that does sort of elide personal and private.
It does. And if the courts, but anyway, the point is that they are expressly, in the case of Mr. Spendler, accepting their personal. The evidence went further from the defendants, Dr. Guy and Mr. Bowyer. They were accepting private, and they were right to do so. And that's what the judge reported. I go to the second error, if I may. Here, there is an error. This is the second error was said in our chronology at tab 5, page 118. We say that the inquirer's account was set up in 2012 and it's 2011. That's right. That is an error. It was not picked up. What was said was that the errors on chronology and the date is 2012 and not. It's said to be 2012 and it is 2011. That was the error, and I'm accepting that.
No, I think there's another error.
Oh, I'm sorry.
Alleged. The relevant account wasn't set up for 2015.
No, that's a different point.
Right. Well, that's, I think, the material point. I don't think Mr. Sutcliffe is attaching any importance to the 2011 versus 2012.
I think the point he was making was that the chronology does not distinguish between the email address and the email account.
Yeah.
And he says the address was set up in 2011.
And
The account was set up in 2015.
There is an account set up in 2015. That's right. So the address is set up. That's the date that we got wrong. And there are references in the judgment. It's J56 to 57. Page 306, but I don't think that can be right. It must be 20. But that suggests that the Google emails are migrated to a new account that's set up in 2011. That's what happens in 2011, not 2012. And then what happens in 2015 is dealt with at J212 when Google is replaced with Microsoft and FastHost. Yeah. So that is the position. And if it's misstated, then I apologise. But so far as the pre-2015 emails are concerned, insofar as they were on, the address, the email address inquiries at Axnola had been used for a considerable period of time by Mrs. Brake. The material period that's being used is
just say that again.
The address, enquiries at Axnola. There is an email address, enquiries at Axnola, which is used by Mrs. Brake. In terms of pre-2015, The judge deals with this at J84 to 86. And it pointed out, there's a witness called Carl Pierce, that there were 300,000 emails before 2015 on an old hard drive which he'd examined. But you couldn't access them. There's a problem about access. And he says there is a subset of the 300,000 which come from the enquiries at email address. So that's, Carl Pierce could not say how many. Nobody could get them.
Could you, why does that matter?
I've got 84 to 86 is what I said.
Why does it matter?
Well,
you can't access them. How is it Article 8?
No. What ones are you talking about? The use of of an address, the architecture, to use my lord's expression. The architecture changes, but the address does not change.
Right.
So the address which has been used by Mrs. Bray, this is a small business, always was. It's a micro business. It's weddings and a small lettings. That's used by her. That address is used throughout. The architecture changes. There is a new fast housed account in 2015.
Mr. Rogers, it's not being suggested that the explanation of all of this and the chronology that the judge sets out from about 82 or so onwards is wrong in any way. No.
Well, I can't. Of course, I can't challenge
No,
it.
exactly. So I'm not
that's
sure
where
where
it
we're
is.
really getting to.
Well, the judge is sceptical about the absence of emails. He said that you could have got them from somewhere else. So I think that's the point that Mr. Sutcliffe wants me to make about J85.
Well, there are some
It's
inaccessible
small.
emails on an old system,
Yes.
which may or may not contain material which is personal stroke private to Mrs. Bray. Nobody knows because you can't get at
The
it.
defendants don't have them. So for that extent, we're dealing with the post-August 2015 emails.
Yeah.
Yes.
But in terms of the expectation, the usage that's going on in relation to that account, why Mrs. Brake is using it in that way, she doesn't start at day one
No.
with August 2015. She starts August 2015 with fast hosts under the setup that's introduced in August 2015. But she doesn't start from there.
Okay, so you say that you're, in assessing the reasonable expectation of privacy, the judge was in a position to rely on how Mrs. Brake had used the earlier address when it was a Google address. Is that what you're saying?
Yes.
Or where's
It's a factual.
where is the evidence of that?
It's not. There's a question about the date from which she's using it and how many emails there are, but that she was using it prior to 2015 was not an issue, and that's why I go to J45, J84 to J86.
Yeah, all right.
And this is a very small point in terms of how many accounts were set up in August 2015. There were 5 set up at that point. In
2015?
Yeah.
Yes.
There's the letters in supplemental file 1, tab 737 refers to email accounts A to D being set up. That's a response to a letter which actually is not in the file, doesn't matter, but there are 5. They are Aloe at, Andy at, Rebecca at, Saffron at. Those are accepted to be set up, and then there's enquiries at. So
The judge says that.
I don't know
somewhere
whether
in
the
the
judge say that, but
He does, somewhere.
he's right about that. That's what
Just going back to the point you were making about what you might call the continuity of use of the address between from 2011. I mean, the judge does deal with that in his paragraph 85. He basically says there's no tangible evidence of this. But that's his conclusion on the evidence. I mean, you may say yes, it was used, but that's what the judge found.
Well, there we are. The
I
third
hesitate to interrupt, my lord, but there's also at page 218, when he's dealing with the issues, it's issue 2 on page 218.
Sorry, 218.
218, issue 2 in his summary.
Yes.
It's set up. There's only seen one email.
Yeah.
There we go. The The third error is said to be this, that we are said to have said that the judge gave decisive weight to ownership. In terms of what we said in our submissions, our skeleton at paragraph 21, we actually say that the question of ownership and or a legal entitlement to ask for the password as if they were decisive. That's what we say. And I accept there's an all there, so one can read it as we're saying ownership is decisive. We're treating ownership and a legal entitlement to ask for the password. I accept that the judge said it was not decisive at J191. But we are not dealing only with the bare question of ownership. It's not the fact of the ownership that's encompassing here, it's what the judge says follows as a result of the ownership. Effectively, it's the employer's email. It's their email. They have all the rights to it. And what we cite in our skeleton at our skeleton paragraph 21 are the passages in the judgment at J238 to J240. That is what we're criticising. And in particular, we note paragraph J240. You were taken to it yesterday by Mr Sutcliffe. And the point is the ownership point, that once Cheddington owned the business, those who held the keys to the company's secrets were bound to cede them to the new ownership, to the new owners on request. That becomes a very compelling, as if decisive, we said too much weight is given by the judge to it. And there are other references to the account.
Well, is it wrong?
That it's
Is it wrong? I mean, if you are employed by somebody, and in the course of your employment you use an email account, let us suppose, for business purposes, which may have some of your own personal material on it too, and your employer says, I want the password to the business account, as an employee, can you say, no, you can't have it? Really?
well, that would be that begs the very question.
I mean, you might say,
Yeah.
I'm going to take my private material off it first, but you couldn't refuse to give the password over to your employer if you're using the employer's business account, would you?
But that's the elision that's been taking place here, is that because the ownership entitles the owner to the password, an entitlement that was never exercised. It was the Guy parties did not want or need access. Perhaps they are legally entitled to the password, but they didn't ever have it. One's got to look at the practicality.
No, okay,
And
I
so that's
understand
why
that point. So
that's
you're
why
not saying
the judge.
you're not saying the judge was, as it were, legally wrong in saying that the employer had an entitlement to the password. Your point is they never actually asked for it.
Exactly, and that's why the weight is too much weight is given to it.
Yeah.
It's certainly, whether it's right or wrong, Mr. Allen, having taken advice, because of course Mr. Allen was the IT man, he got his NDA confidentiality agreement with Mrs. Brake, he takes advice and he gives the password over. So that's obviously that's what he thought the position was that they were entitled to it. But the question of the legal entitlement is one thing. Not suggesting that it's your account, you should have the password. If it's yours, essentially you can do what you like with it. But that's not to say that all of the information on the account which you own is yours. That's a different point. And that's where the judge slips into error, we say.
Yeah.
Where does he actually say that because all the information belongs? Where does he say that?
No, he didn't. No, he didn't. No, he treats the ownership as being the decisive factor. Once you are entitled to the keys to the account, once you're entitled to the company's secrets are bound to cede them to the new owners. That's J240, I think. You're bound to hand over the password.
I don't read 240 in isolation.
No, of course.
It goes on to 241.
Yes.
In other words, his reason for not accepting the proposition 7 in 238 is not just what's in 240, but it's what follows in 241.
Of course, and one reads on into 242, where he's talking about the question of the beneficial ownership. So he's got ownership running through as a theme.
Yeah, well, I think you accepted yesterday it was a relevant fact.
I accept it's a fact. He gives it too much weight.
Yeah.
And that's why we say if you're looking at the facts, you look at the facts as they were, in a sense, on the ground. What's actually done. It's not just a question of, well, they've got a legal right because they now own the business and they now own the domain or the account or whatever it is. The ownership is not disputing that. It's a point not disputed on the appeal at all. But the consequences of that, it doesn't mean that there's nothing left to protect by the fact that my client's plural information, private information, is on the thing which somebody else owns.
But the judge doesn't say that either, does he?
No.
He goes at 241, last 3 lines. He said that does not deprive her. He's talking about the email account having changed ownership. That does not deprive her of all rights in relation to them.
That's the very
emails.
point.
But it does change the context.
Of course.
And you don't disagree with that?
I do not.
Right.
And of course, in terms of the case that's being advanced now, a lot of weight is still being put on the fact that the employers are entitled to access it. They're entitled to the password, suggesting that Mrs. Brake has access by virtue of her employment. I'll come on to that. It picks up in what's said to be error number 5. But anyway, the short point is, there is an argument here on this point, which I accept there is an argument between the parties. I do not accept it's a misstatement of fact.
Right.
So that's where I come to with that.
Right.
Fourth error. Remind you, Lordship, there are 7. I'm taking as quickly as I can. This is the question of limited access to the inquiries account. And 2 paragraphs of our skeleton were drawn to the court's attention. 21.3, which refers to the limited access by 2 other individuals to the account. This is the first reference. And the second is there was only limited access by 2 AEL employees. And that's where it's pointed out it was with Mrs. Brake's knowledge and consent. Now, it begs the question what you mean by limited. But it's not a misstatement to say that the access was limited to those 2 employees. There's Mr. Allen as well, who's the IT man with his NDA with Mrs.
That's the sense in which you're using limited.
That's the sense.
There was a small pool of people.
There were 2.
3.
But with Mr. Allen, there are 3.
4, including Mrs. Brake.
4 including Mr. Allen.
And Mrs. Brake.
Mrs. Brake, of course. That's the
Brake,
point.
Mrs. Holt, Mr. Winder,
Yes.
and Mr. Allen. So that's 4 people
Yes.
used or had access to this account.
Yes.
And that's the sense in which you are using the word limited.
I was actually using it in the sense of limited to the 2 employees because I was referring to Holt and Winder. So I accept that Mr. Allen
So
has the access
all right.
as well.
So when you use the word limited, what you mean is
It was limited to those 2.
that those 2 were the only people.
No.
Who
Rather
had
than
access.
the access being limited.
The access which they have been
All right.
limited.
Well, that's clear.
I'm going to.
That's very helpful. That's cleared that up.
But I'm going to come on to, we need to look at what that access was and why it doesn't destroy the reasonable expectation of privacy. It's a proposition, if I may say so, that's so obvious I found it difficult to find a succinct encapsulation of it in an authority, that the fact that information is shared amongst a small number of people does not deprive it of its private character.
Well, there's no reasonable expectation of privacy, is there, so far as the other 2,
No.
3 users of the account? So
That,
Mr. Winders. Okay.
well,
No.
I'll come back. I'll come to that if I may. This is a small operation. I've said it's a micro business, basically run by Mrs. Brake and a couple of people. Now, bear in mind, as the judge found at this is J30, page 144. Mr. Winders had worked with Mrs. Brake on 2 separate occasions, including the previous partnership, and she had called him one of my closest friends. That's the access that's being shared. There's reference at the judgment at 6 to Mr. Winders having been a housekeeper and PA at some point.
J which?
I'm sorry, the first reference I gave was J30. That's the reference to Mr. Winders being one of Mrs. Brake's closest friends.
Yeah.
The reference to his previous employment is in J6, page 192. And J110, and this was, I know the court was taken to this yesterday, at one point he has the password to the @Allo account and when she had medical treatment to take her out of the office. And it's a small point, one of the points that Mr. Sutcliffe made this morning, I think it was his third point about the transcript of paragraph 51. In answer to your Lordship's question, Lord Justice Baker, the question to which I was directing the answer was whether the password was transferred, which we were saying didn't happen, not saying that Mr. Windus didn't have access. So that's a small point. We say it can't
Sorry,
be.
I don't understand.
I'm sorry. It was a point that was made this morning that transcript 51, effectively false instructions were being given, because the emails are shown, which have gone into the file today, showing that Mr. Windus did have access. We know Mr. Windus had access. We know that he used the account, but the question is whether or not the password was transferred to him, and that's a different question.
Well, the emails we were shown shows him answering emails when Mrs. Brake is out of the office. We've been told that the account was password protected, so he must have had the password.
It doesn't follow,
wasn't
I'm
he?
afraid.
How did he get in without the password?
Because he's given access. You can be given access without being given a password.
Is that what the judge found?
He didn't find the opposite. The finding in relation to the password to which Mr. Windus was given access was the @allo account. That's in J110.
Well, are you saying the judge found that Mr. Windus did not have the password to the inquiries account?
I'm not saying that he made a positive finding to that effect. He
Well,
didn't make a finding the other way.
I don't think you can start telling us what your client says about it.
No. Well, but the fact is that I did tell the court yesterday, and I've been told. It suggested that I was wrong in what I said. All I'm saying is that there is not a finding.
There isn't a finding either way.
There isn't a finding either way. So
Sorry, is the closest one has at 110, which is
yes.
In addition to Mrs. Brake, Simon Windus also used the
Exactly.
inquiries account.
He used
And
it.
you're saying using doesn't mean you've got the password. Necessarily.
And there is a specific finding that he had the password to @allo at a particular time.
Yes, that's the
But
bottom of that paragraph.
It only matters because it was being suggested that the two emails that have gone in before the court show that what was said to the court was wrong, and we say it wasn't. But
I don't think that.
It's such a small point.
The reason why those emails were put in was they were showed that it was a shared, to use my Lord's phrase, a shared space.
Well, that's the finding. The finding is that he used it, and in fact, the judge goes so far as to say he had, I think it's unrestricted use at one point.
Well, do you accept that there's no reasonable expectation of privacy as against Mr. Windus and Miss Holt and Mr. Allen?
No, I do not. In relation to Mr. Allen, there's a contract.
Okay.
So he's different. In relation to Mr. Windus, what I'm saying and what I need to say is the fact that Mrs. Brake shares information with one of her closest friends because he has access.
This is a new case, I think.
No, it's not. I'm afraid it's not, my lord. He is one of the closest friends that she shares with him that information. He has access to the account. The question for the court is, as it was below, is does that destroy a reasonable expectation as against the Brakes?
He didn't share the account because he was a close friend. He shared the account because he was an employee.
He shared the account because he was using it for work because he was an employee.
Yeah.
In terms of the circumstances and the factors, are who is having this account? It's Mr. Windus, who's one of her closest friends.
What about
What's
Miss
the
Holt?
expectation?
What about Miss Holt? She used it.
Oh, well, I'm going to come on to Miss Holt if I may, because I'd like her.
Is this the way the case was put below? Find no trace of it in the judgment. There was a small group of confidants with whom Mrs. Brake was content to share her private information.
It's certainly put on the basis that the fact that Mr. Windus had access does not destroy the reasonable expectation.
I'm sorry, you can't sort of wiggle around these things. The way that it was being put against your client below was this was a shared space. Different employees used this account for the purposes of the business, And that eliminated, or reduced if not eliminated, any reasonable expectation of privacy as against her employers that your client might have had. If it was going to be suggested, oh, but there was a close circle of friends with whom I shared private information, then that ought to have been run before the judge, and as far as I can see, it was.
I'll double check precisely how it's put in the submissions. But the fact is that it was shared with a person in that position, as the judge found. That's the extent, and we say it's a limited extent to one person.
Well, I'm not sure that he does actually find that. What he finds are two things which he doesn't link. One is that Mr. Windus was one of Mrs. Brake's closest friends. He seems to accept that from your client. And the other is that he used the inquirer's account for the purposes of the business. He doesn't say that Mr. Windus looked at your client's private material. He finds that Mr. Windus did not use the account for his own private material.
Exactly.
All he finds is that Mr. Windus and Miss Holt, for that matter, used the account for the purposes of the business. That is as far as you can take it.
Well, the question is whether or not the fact that Mr. Windus used the account destroys the privacy as against the Brakes. And we say no.
Yes, but that's because you're now putting forward a case that this is a close circle of intimates whom she was content to share. Anyway, you've made the point.
The judge, well, we do make the point. And just in terms of what the judge finds about Mr. Windus, J121, he refers to him as a trusted colleague of Mrs. Brake. This is why he's asked to take on the job of sifting personal stuff on the account. He notes that J181, that the letter of wishes, obviously a highly personal, we'd say private and confidential, letter was written to Mr. Windus. I note it's given to Swift, it's said here. And it's said that Mrs. Brake knows that others, Holt and Windus, have access to the account, and that's J241 and J265. And as I've noted, the judge says he had unrestricted access. Now, that's why we say it is a limited access. Is it sufficient to destroy the reasonable expectation of privacy? No. What about Mrs. Holt? I said I'd come back to her.
Well, could I just take you to 241 before
Yes,
you?
of course.
Maybe this covers Mrs. Holt as well. Isn't it clear for 241 that the judge was treating Mr. Windus for the crucial purpose, not as a close friend, but as a colleague?
Trusted colleague, I think. Oh, sorry, trusted colleague is J14121, not 241.
An ultimate sentence of
She's
241.
She's a colleague. He's a colleague, sorry, or they're colleagues. I accept that. But does that bring to an end any expectation of privacy that would otherwise have existed as against the guy parties?
But with respect, the judge doesn't say it does.
No.
At the end of 241, he says it doesn't deprive her of all rights. So he says that. And you, in answer to my lady, you said you accepted that.
I do.
Yeah. So what's this point all about?
The point is about the limited nature of the access, which I'm simply reinforcing what the limited access was from the passages of the judgment, which are not challenged. So far as Mrs. Holt is concerned, J71, she's appointed as a director in September 2015. She goes on maternity leave in June 2016, and she never goes back. So she has access to the account. It's limited, again, in the sense that in terms of time, she's gone in June 2016. And the same point is made at J83.
She's not called a close friend or trusted colleague.
No.
Yeah.
And as we say, the fact that information is known to a small number of people doesn't prevent you from asserting a right of privacy against others. Could Mrs. Brake assert a right of privacy against Mr. Windus? Well, obviously, it would depend what Mr. Windus was trying to do. If Mr. Windus tried to publish something highly personal, perhaps she could. The fact that she shared information with him wouldn't mean that he could publish it. But it's not a reason. There isn't an issue with Mrs. Holt or Mr. Windus. One's got to focus on the guy parties, if I can put it that way.
You'll bear in mind, Miss Rogers, you've only got till 1
I'm not going to be anywhere. Well, time flies. Fifth error. It said that it's an error for us to say that AEL did not have access to or control over the password. They had an entitlement to it, but they did not, in practice, in fact, have it.
Yeah,
They didn't use it. They didn't exercise any control. So one's got to look at the realities. And the suggestion that it was suggested that, in fact, even Mrs. Brake only has the password because she's an employee of the Guy parties, and therefore she can't rely on the fact she's got a password as against them. But if I may say that's a submission that can't really be runnable in this case, because the fact she holds it as an employee doesn't mean that she's got no reasonable expectation of privacy in relation to the information on the account.
But you do accept that she held it qua employee.
She was an employee and she had the password.
And after the sale to AEL, that was the only basis on which she could have had the password to an account which was owned by AEL. Again, I'm sorry, I don't want to repeat myself. The fact is that she did have it because she was the one running that aspect of the business. They didn't because they weren't. That comes to that. Sixth error, penultimate. It said there's no relevant contractual. We say we're wrong to say there's no relevant contractual term in this case, and that paragraphs 5 and 24, 2 and 3. What we said at 5 was there isn't a contractual term prohibiting the appellants from making private use of the email account. There wasn't. There wasn't a contractual term permitting the respondents to monitor it. There wasn't. So that's what we say. We say there isn't a relevant contractual term. As for 24, 2 and 3, we're dealing there with the question of Simpkin, and we're referring by contrast to the express terms in Simpkin, which we refer to in 24.1, which do not exist. There is no relevant contract term. The contract term at 16.4, of course there's a contract and of course there are terms. We don't accept that the 16.4 term is relevant in this context to the question of whether Mrs. Brake had a reasonable expectation of privacy. She's got to hand back her employees.
I don't think contract terms are Mr. Sutcliffe's best point.
Fine, then I'll pass on. In terms of what, if one's thinking about what the expectation of privacy was, it's been suggested that Mrs. Brake wasn't given an assurance by the Guy parties that when they took over things were going to change. There's no assurance being given. And in that context, the court hasn't seen the clauses that are taken out of the contract. And
I think the judge refers to them.
He does. And effectively, the term that is suggested, which is taken out, is that we can monitor. And that is taken out. So in terms, again, of Mrs. Brake's expectation, she's running the business, she's the one who's doing the staff. Is she told, New World, August 2015, now we're going to look at everything? Quite the contrary. There is nothing like Simpkin. We have copies of the contract with the contractual term taken out.
Well, Judge quotes it.
Then I'll leave it there. And, there we go. And the last point, it's said that we are wrong to say in our skeleton that at the first trial the judge was concerned only with the first stage of the two stages of the misuse of private information tort. Can I ask the court to look at the closing submissions of the respondents, which is the second supplemental file, tab 4. And the page is, 160.
160.
And it's paragraph 119.
Yes.
Stage 2, the balancing exercise. The issues at stage 2 are reserved to a second trial, subject to the outcome on the preliminary issue. Accordingly, if the Brakes succeed in establishing at stage 1 they have a reasonable expectation of privacy in relation to the inquiry account, the interim injunction would need to be maintained pending that second trial. I'm going in looking at the context of where the two elements are put.
So you say then at the trial which actually took place, it would not have been open to the guy parties to say, well, forget about allegations of iniquity, even if there was a reasonable expectation of privacy. What we actually did either was a justified interference or was not a serious enough interference, or one way or another did not give rise to a breach of Article 8. You say they wouldn't have been able to argue any of that.
The reason they can't effectively argue that is because the question of what they did and whether they were entitled to do it is a stage 2 question.
No, that wasn't my question.
Oh, I'm sorry.
The order appears to have sent for trial everything apart from the question of iniquity.
Yes.
And reading the order without paragraph of the respondent's closing submissions that you've helpfully shown us, I would have thought myself that if the guy parties wish to argue, forget about questions of iniquity, let's assume there is no iniquity, it would have been open to the judge to say, yes, reasonable privacy, there was an expectation of reasonable privacy, but what the guy parties did was not a breach, either because it was justified under one of the other heads of Article 8.2, or because what they did wasn't serious enough to give rise to an actionable tort, or whatever. You say he wouldn't have been able to do any of that.
I do. And the reason being that the foundation for what the guy parties did in terms of passing information to third parties is to expose wrongdoing.
Yeah.
So that the very question of can you pass it to Mrs. Breen, the trustees in bankruptcy and so on, depends on that issue which has been hived out. And how that had come about, as I say, that you have, it's on the Judge Matthews order on the 4th of August. And there was a slightly surprising submission made yesterday that the defendants had to satisfy the judge there was a prima facie case of wrongdoing and then there'd be a second trial. That's not an issue, that whether there was a prima facie case of wrongdoing. Wrongdoing as a whole is the stage 2, and 119 confirms what we thought was the case and what is the case and what the judge says is the case in preliminary issue judgment, paragraph 40, second stage issues. So that's, it goes on. And in terms of how wrongdoing arises, there is that floating point that the judge makes in J236 to J237 as to whether or not iniquity comes up at stage 1 or wrongdoing comes up at stage 1. But can you have a reasonable expectation of privacy? And again, it's important to note, if I may, the way it was put at trial in relation to that, both in opening and closing submissions, it was not suggested by the breaks that any question of wrongdoing arose in relation to the reasonable expectation of privacy. And if I may, I'll give the court the references. In the opening submissions at trial, this is tab 2 of the second supplemental file, at page 61, the breach of confidence elements are set out at paragraph 68. It's said that there are limiting principles.
Just hold on a minute. So that reflects your bundle 2, page 61. This is the guy party.
This is the guy. I'm only taking you to the guy
Yes.
parties because, well, I'm only taking you to the guy parties.
Yeah,
Well, which-
breach of confidence.
So this is the way it's put is the breach of confidence first 68. Coco and Clark, perfectly standard. 3 limiting principles at 69. Doesn't apply to trivia. Doesn't apply to doesn't apply to public domain, doesn't apply to trivia, and then third, the limiting principle: the public interest in confidence can be outweighed by some other countervailing public interest feature which favours disclosure. That's a major issue which is addressed in the supplemental, so in the written submissions on the preliminary issue. That's because it's a preliminary issue, it's an iniquity issue. So that's breach of confidence. The way it's put there is that public interest is effectively the wrongdoing, and it's not suggested that affects the question of whether it's confidential. Similarly, paragraph 70, we have the elements of the breach, the misuse of private information claim, set out in the conventional two stages. 1, reasonable expectation of privacy. 2, balancing of all the factors. And it's said at the end of little 2 there, under paragraph 70, page 62, the last line, the main countervailing factor in stage 2, the main countervailing factor in this case is public interest in exposing the break's wrongdoing. Stage 2 test, iniquity, not surprising because that's where it's going. Now, the case on no reasonable expectation of privacy is dealt with, as one would expect, pretty shortly in the opening submissions, paragraph 72 to 74. Not suggested that any wrongdoing is relevant to the existence of a reasonable expectation of privacy.
Yeah.
Closing submissions for trial, just to complete the picture, is the same. Tab 4, same file, page 145. I was going to start with misuse of private information at paragraph 90, and that is page 145. By now, the elements are said to be 3 rather than 2. It doesn't matter because we've still got the distinction between reasonable expectation of privacy, which is element number 1, and then the if there is it outweighed as element 2. That's still there, and there's a third issue introduced. Now, on the following pages, from paragraphs 95 onwards, 11 factors are put against there being a reasonable expectation of privacy. We have checked and rechecked this. Alleged misconduct is not one of them. It's pages 148 to 160. And we get to stage 2 in the submissions at page 119, which is the one I showed the court moments ago, which is the second stage test. The issues at stage 2 are reserved to a second trial. That's misuse of private information. I started with that. I should go just to breach of confidence rather briefly. And the elements of the claim set out again, paragraph 71, pretty much the same as they were at the outset. Accepted elements and accepted limiting principles. And then there's an attempt to take the case down on various grounds. The case is improved by the claimants. The public interest offence is raised, and what is said there is if the court is considering whether it's arguably in law. If so, no final relief can be granted ahead of the second trial. Now, in those circumstances...
Well, all right, stage 2, the balancing exercise, but the closing submissions for the Guy parties also refer to stage 3, misuse.
Yes.
So they're not treating the trial as limited to stage 1.
They are not.
So if the judge were to find, yes, there was a reasonable expectation of privacy, I leave aside iniquity, but there was no misuse, the claim fails.
That would be right, but the question would have to be, we would say you cannot decide whether the use is misuse, particularly when it's disclosure to third parties, without looking at the question of wrongdoing, and wrongdoing isn't there, so the court can't determine it. I was going to just mention, as JR38 has come in, we say the reason, in a sense, why JR38 and Asplin weren't cited to the courts, either at the trial or the preliminary issues, because the way the case was put was that the reasonable expectation of privacy was not being alleged not to arise because of wrongdoing. So it didn't arise. So we've got JR38 now. It wasn't relevant before the courts, and we say it wasn't relevant. It isn't relevant now. It's a very interesting point, of course. It's film of rioting in the streets, including images of young people. The police are trying to identify those involved. Lord Toulson with Lord Hodge and Lord Clark in a separate judgment approach it on a plain Murray basis. Certain paragraphs have been mentioned by my learned friend. Can I ask the court to note the following? 87 to 88 from Lord Toulson, and he's warning against including at the touchstones test that the reasonable expectation test matters which ought to be in the second stage, quoting Lord Nichols and Campbell. And the question he puts it as at this first stage is, are you in the sphere of Article 8? Of course, that's not the definitive answer to whether or not you make out your case, but if you're in the zone, if you're in the sphere, is the first test. The respondent said, I think, 97 to 98 in an email this morning. We say also look at 101, and the question is the publication of pictures taken of public writing for the purpose of identifying those involved. If you're in the street and you're writing, people taking pictures, very hard to say that's within Article 8. That's what Lord Toulson said, applying a plain Murray basis. Lord Clark gave a separate speech because of the differences between Lords Toulson and Carr, and at paragraph 105 following, he explains why he supports the Murray principle. It's on the facts of that case that what he was doing was engaging in public disorder in the street. It doesn't fall within the scope of Article 8. Whereas Lord Carr, paragraph 31, is asking the question, is Article 8 engaged? He notes the very broad scope of it at 36, and then in terms of how he approached it, this is the minority, 39, 41, 43, 53 and 54. Axon, again, Axon applies JR 38, Kinloch, which is a case cited in JR 38. You're looking at all the circumstances, and in the factors lettered A to O, it's factors E and F in paragraph 64, which both sides say, where in that case, on the facts of that case, the judge takes it as a factor. Can I say one thing about Simpkin in this? It's not quite this context, but it's on matters of law for a moment. It's factors. One has to weigh factors. Absolutely. Look at all the facts and circumstances. In looking at the question of Simpkin, we do say the judge was wrong. We say I'm not going to repeat what we said about that. But as to how Mr. Justice Garnham approached the question, he looks at the question of reasonable expectation of privacy. He introduces it in paragraph 31 of his judgment. And in paragraph 38 of his judgment, he says, in those circumstances, i.e. referring to the circumstances in which preceded it, paragraphs 32 through to 37, in those circumstances, taking them all together, he finds no reasonable expectation of privacy. So he takes all the facts into account. And to try and say that one of those factors outweighs all the others is simply wrong. While I'm on law as well in this context, it's said we can't rely on Copeland for analogy. Copeland states the principle, and it's the breadth of the principle which is stated in Copeland, which these emails, these communications fall within the principle that's stated in the case, in Strasbourg. It was suggested that we've dropped Barbalescu. That's not right. We've cut down authorities for the court. We relied on it then. We relied on a trial. We relied on it in our submissions. We says we rely on it now. We tried to cut down the authorities for the court in a perfectly. If it's suggested
well,
that
I think
dropped,
if you want us to read it, you better send us a copy.
I'll send copies. But I'll note this as well, because I don't want to burden the court with material unnecessarily. The judge does cite part of it at J251 to J255. So it is referred to in the judgment. I accept that he refers to it, but what we're saying is he gets it wrong because he doesn't appreciate the breadth of Article 8 in this context, in the employment conduct. A few loose points. I just want to say which are the ones that matter sufficiently to deal with the court. I think simply this. In terms of sort of bright lines, it said there are no bright lines in the cases anymore. In a sense, that's true. There used to be very clear that if something's in the public domain, for confidential information point of view, it fails because it loses that quality of confidence, it loses the inaccessibility. It's not so simple in privacy. The fact that something is, even if it's being published very widely, and it's repeated, the repeated publication of private information.
Well, there was that case about PJ, whatever
it's PJS.
It was, where it was all over the internet, but nonetheless
But
the
you can
Supreme
still
Court
injunct
stopped
it,
the newspapers.
Absolutely, because the wrong is the autonomy and the privacy right endures. It's not like confidence, which is the iceberg melts, it used to be said. And the public interest test, we say, is still there as a limiting principle, formally referred to as iniquity. It's the public interest, a second stage test. So generally the debate is second stage. There's no determination of wrongdoing by the judge. That wasn't before him, and he doesn't determine it. The only question where there had been a question about wrongdoing at the earliest stage dealt with by Mr Jarvis QC. In his judgment at paragraphs 50 to 67, it was suggested that legal professional privilege couldn't have arisen between the Brakes and their lawyers because of wrongdoing. And that was, of course, the test at that stage was, had the Brakes shown a strong prima facie case of unlawful conduct. In paragraphs 50 through to 67, Mr Justice, His Honour Judge Jarvis, Mr Jarvis, sitting as a High Court judge, rejects there are 3 attempts at setting out an unlawful scheme, and he rejects it. And of course, that is the test when you're knocking down legal professional privilege. If you're saying that iniquity, public interest, knocks out a privacy or confidential claim, the question for the court is not whether somebody thinks it did, but whether it actually did. So the court looks at, is there wrongdoing or not? As I say, that wasn't determined by His Honour. It couldn't have been determined because it wasn't before the court. And the fact that it doesn't depend on what somebody believes, if authority is needed, is to be found in the Mosley case of Mr Justice Eadie in the files. Lastly, what is in the files, and I'll take this very, very shortly. Mr Spendlove deals with what was dealt with in Mrs Brakes' witness statement, I think from November 2020. That's dealt with at a point where, of course, they're sacked. They don't have any access to their emails for a year. That's how this whole thing started. Mrs Brakes' witness statement in relation to what was in the files. Paragraph 4, supplemental file, first supplemental file, tab 16, page 186, paragraph 4, she says, it includes medical, family and friends, son, school, etc. Not challenged. Mr Guy's witness statement, just draw attention to this, tab 15, page 159. From paragraphs 10 to 13, is why did he want access to the account? One of the points I know has troubled the court is, what if an employer wants to investigate wrongdoing? It's an interesting question of employment law. The crash course I engaged in last night broadly accords with what Mr. Sutcliffe says. You can't do it. You can't have access to something private to self-help. You can't do it. But that's not this case. The Guy parties had sacked Mrs Brake and Mr Brake. They weren't looking for wrongdoing. That's specifically what they say. So the court doesn't need to worry about that in this case. That's not what they were doing. All they wanted to do, as Dr Guy says, is we didn't have any reason to access the account prior to the dismissal. We didn't go looking to obtain evidence of serious wrongdoing. We didn't know it existed. We simply wanted to protect the business and get on with it. And then they say they believe they're entitled to pass it to interested parties. Now that depends on whether it was iniquity or not. Lastly, in terms of what is the purely personal material, could the court find this purely personal? It's not disputed. Spendlove 2, which the court hasn't looked at, he reviews the mechanism that Mr. Spendlove is doing is what's business, what's personal. He looks at the certain categories. This is page 206 of Spendlove. It's supplemental file 2. The tab would be and Mr. Spendlove.
Sorry, which tab?
Sorry, tab 17. Spendlove 2.
Of what?
The first supplemental.
First one.
First supplement.
You said
I'm so sorry. It's because I call it file 2, and it's actually the first supplemental.
Right. Tab 17.
Tab
Yes.
17. This is Harry Spendlove, the solicitor who's doing the review. Are they business or are they personal? That's what he's looking at. And he says in paragraph 10, he looks at the materials which had been identified by Mrs. Brake in a witness statement in November. This is at a point before they get access to the materials. The categories there, not identical or not in the same order as the issue 12 issues, but those are the categories that are looked at: medical, letter of wishes, sun school, social media, Ritchie, Fowley, Loxley, and so on. And he identifies at that stage the documents which are in those categories. And that's increased in Spendlove 3, which we've looked at. It goes up from 3878. Did the court have a basis to find that there was private email? There were private emails on the account. Yes, on the uncontested evidence coming through Spendlove, coming from Mrs. Brake, that this material was there. Once that private material of this nature was there, do you need to see every document? No. No, you don't. It's there. Do you have a reasonable expectation of privacy into it? We say it follows. And the judge, the final question, Lord, you had to, Mr. Sutcliffe, I say it's perverse. Is it perverse to find no reasonable expectation of privacy in relation to that kind of email? We say yes.
You say yes.
Yes, it is perverse. I have looked at these references. I rely on those behind me. The question was, am I changing the case in relation to the narrow, the limited circulation, Mr. Windus, Mrs. Holt? I'm told that the Brake's closing submissions, which would be the second supplemental file, tab 3, pages 88 to 90, are effectively, it's the way I put it. It's the way it was put. So
88, pages 88
to 90. I'm sorry.
That's paragraphs 47 to 49.
Yes,
All right.
I'm told that's right. 47 to 49. And similarly, how is it put in the evidence? Mrs. Brake's trial witness statement.
No, we can't look at Mrs. Brake's trial witness statement. We have to go on the findings of the judge, particularly since the judge did not accept much of Mrs. Brake's evidence.
Well, this material is before the court by agreement in the agreed files.
It doesn't matter whether it is or it isn't. We work on the facts that the judge has found.
But what was put to me was, how was it run at trial? In terms of how it was run at trial.
You're showing us how it was run at trial.
Not just on the submissions, but in the evidence. And I'll give the reference, but I'll leave it to the court whether it looks at it or not. It's supplemental file 1, tab 16, page 192, paragraph, is that 16D? 16D.
Sorry, could you repeat that? SB1.
Yes, SB1, tab 16, page 192. Yeah, page 192.
Thank you.
And it's paragraph 1616D, Mrs. Brake's trial witness statement. So that was how it was run. It's not a swerve. Thank you.
Mr Sutcliffe, are you entitled to a right of reply?
I'm not getting up to reply, man. I thought we.
Okay, let's go.
I thought we
Oh, I see, I'm sorry. All right. Well, thank you very much for your submissions. We will reserve our judgment. You will get drafts in the usual way, which will be your opportunity to correct our English, but not our reasoning. And we would hope that in the light of the drafts, you will be able to agree an order disposing of the appeal. If you can't agree an order, please make short written submissions, and we will make the formal order that we think appropriate.
And my lords, I'll send Barbalescu over
Yes,
as
please,
a
thank you.
PDF attachment by email to the clerks.
Yes, thank you very much.
All right.